into the show. We've kind of been on this crusade talking about language and words and how important they are, especially when it's being applied to law. So we have also had a few episodes discussing a new lawsuit and some things kind of involving a really interesting intersection. I have to say that slowly, of a few things. Social media, free speech, freedom of religion, and civil rights are all kind of being combined into I wouldn't say a perfect storm, but definitely a storm and controversy created by Studio 8 Hair Lab over in Traverse City. Today, I like to say, illustrious attorney. He won't say that.
I won't say that.
David Delaney. Many of you probably will recognize, he's been on the podcast before. He is the Iron Pigs attorney, so he has represented me and the Iron Pig in several proceedings in the last 4 years now, we almost have to say. And a lot of those things have been around the way that words are interpreted. For us in the Iron Pig, it was the gathering of people for any purpose and may establish procedures. That language right there was construed to do all kinds of crazy things. So here along comes another case, and we've talked about it before with Studio 8, but I came across a clip on the news, and I want to play it real quick, and then we'll talk about exactly this confluence of all of these things, and actually the simplicity of Studio 8's lawsuit. Can't really even call it a countersuit, but a lawsuit that's coming out. And again, I don't. Trigger warnings aren't exactly what I want to say, but there. I do want to warn you. Listen, you don't need to agree with anything that Studio 8 has said on their Facebook page, but you're going to find out that it's being misconstrued in a lot of different ways. And I just want to play this real quick, and we'll take it from there.
All right. Well, over the summer, a hair salon in Traverse City received repeated complaints of discrimination.
This week, formal charges were filed against Studio 8 Hair Lab. Our Elle Myers joins us now from the Capitol in Lansing with more on the case.
The Michigan Department of Civil Rights filed discrimination charges against a hair salon in Traverse City over social media posts that said the salon wouldn't service LGBTQ clients. Now, the department is arguing that those social media posts are a violation of our state's Elliott Larson Civil Rights Act.
Studio 8 violated the law by denying their services to specific individuals based on sex. In this case, the respondent made sure the people in her community and beyond knew her position by publishing comments on social media, spelling out the people she would refuse to serve and why.
According to the Department of Civil Rights, Studio 8 had 21 complaints filed against them since July of this year. The salon posting that if a person identifies as, quote, anything other than a man/woman, please seek services at a local pet groomer, end quote. This current formal case of discrimination is based on 3 of those cases.
So our perspective on bringing the discrimination case against the salon is this. We have to enforce the laws of our state, right? And that's what the Department of Civil Rights is doing. They are enforcing the laws of our state. They're enforcing our Constitution.
The Elliott Larson Civil Rights Act was expanded earlier this year. The 1976 law already prohibited discrimination on the basis of gender, but was further expanded to include sexual orientation, gender identity, and gender expression.
It is important to say that the owner of Studio 8 need not literally to have shoved someone out of her doors to be found in violation of ELCRA.
Now that the charge of discrimination is filed, the department tells me the next step in the process is a public hearing. For now, reporting in Lansing, I'm Elle Myers, CBS News, Detroit.
Okay, so there we have, in a nutshell, I actually have a lot of issues with that reporting right there, but that's not really what I want to talk about. I just wanted to remind everybody exactly kind of what this case was about from the Department of Civil Rights and the 3 individuals that have filed complaints against her. So again, I want to welcome back in Dave Delaney to kind of give what I always like to say, we always like to say, kind of a breakdown for the guy on the other side of the bar. These are important issues, mainly that there are people that are seeking money damages for something that they read on the internet. That's something that I find crazy and wildly fascinating, but something that is also being kind of left out of some of this. But you guys didn't come here to get my opinion. I want to hear from the legal side of it. Studio 8's representation, Dave Delaney. I've read a lot of this stuff, but you have an amazing way of breaking things down. So I figured to have you in and try and coach me up on some of this and some folks out there too.
Oh, always a pleasure to be here with you, Ian. And, a number of cases do come across our desks, but we only pick the ones, I try to pick the ones that deal with the Constitution.
Or what was it recently said that you are on the front lines of the culture wars?
Yes.
I think because, you represented at least 15 different
correct.
groups or individuals in school mask mandate cases. Obviously, the Iron Pig case was pretty big to do. So I found that kind of entertaining, and it certainly wasn't my go-to thing. That's not why I chose the battle, and I don't think that's why the parents in the mask mandate cases, and I don't think that's why Studio 8 has entered this battle either, to be a culture warrior, if you will. But nonetheless, I appreciate your point of view.
If the case impacts primarily the Michigan Constitution, which in many ways is a mirror of the U.S. Constitution, then I'm going to be interested in it. We talked before about the separation of powers, and I think that I want to revisit that just briefly. It's not the most interesting conversation you can have at a cocktail party, but it is always going to be important, and it's very important now. And so James Madison took the king's power. He was the sole decider of all issues. He wrote the laws, he interpreted the laws, and he enforced the law. And James Madison broke that up into three parts. The legislature writes the law. The executive branch, which is the governor and the president and all the agencies, they enforce the law. That's all they do. And then the judiciary interprets the law. And being able to master those three divisions is difficult because they tend to encroach on each other. I'll give you a couple of examples. The Flint water crisis, irrespective of the tragedy that occurred there, a judge issued the charge in that case under a law written by the legislature. But the courts ultimately set that aside because judges interpret, they don't enforce the law. The emergency powers in Michigan were laws written by the governor, and that was set aside because they don't write the law. And so the legislature probably does the least encroaching, but have the most difficult task, and that is writing laws, which the courts interpret. So, and
it's designed not to be easy.
No,
in my opinion, and interpretation.
It's the most important branch in my view, and the state legislatures, I think, have the most important job. But those are the things that tell us what we can do and what we can't do, and it restricts our liberty. So it's the most important area of the law writing in this case. Just by way of comparison, the Constitution, the U.S. Constitution, and as developed by all the 50 states, the Constitution defines the rights of the government. And what are those rights? We just discussed them: legislature, executive, and judicial. Now, what's the Bill of Rights? The Bill of Rights limits those powers of the government. Okay, First Amendment, freedom of speech, freedom of religion, freedom of press. Second Amendment, the right to bear arms, The Fourth Amendment, search and seizure. Fifth Amendment, dealing with self-incrimination. Sixth Amendment, right to counsel. Seventh Amendment, right to a jury. So those are the rights of the people, and those limit the power of the government. So going back to what you said about the guy at the bar, when an issue is presented to you and you don't know what you just heard, that creates a problem. Okay. Right. So in the video clip, there were a number of things I disagreed with because it reimagines the facts and stated things that did not occur. I'll give you an example. If two people at the bar are watching the Lions game and there's a catch in the end zone, we don't know whether he was inbounds or not, at least those two people two gentlemen, two ladies, what have you, can look at the same video in slow motion and make determinations from there. If I'm just coming into the bar and you're explaining to me what just happened on the TV, but I can't see it, then I have to rely on what you saw. I got to see it to know what happened so I can argue over it. So let's move forward to this case. We have something that's called a public accommodation law, okay, written by the legislature, enforced by the executive, and it's going to be interpreted by the courts. Now, what is a public accommodation law? Well, the primary purpose of those laws, going back to the 50s and even into the 1800s, quite frankly, was that people of race should be allowed, irrespective of their race, to get a hamburger, to get a cup of coffee. And I think everyone is completely acceptable of that. The next category was religion. And I don't think you see as much of that, but you certainly see it. But I don't think that anyone that comes to your restaurant, irrespective of their religion, sometimes it's obvious and sometimes it's not, based on attire, that they can be refused service. Then the next issue was sex. And what they meant by that initially was gender. So in the 70s, we didn't want corporations only hiring men. Women should be allowed, and they had lawsuits, and the court said yes. Just because a person is a woman and just because a person is a man doesn't mean you can discriminate. They should be able to get the employment.
A protected class.
Exactly.
Okay.
So now we're into an expansion of that area. And that expansion includes sexual orientation, which means same-sex marriage, and the newest category, gender identity. A person is born with a gender and wants to relate to a different gender. In Michigan, they have divided the law into two sections. And those two sections are denying service. And the second section is communicating that you're going to deny service. Mm-hmm. This is a law that was drafted in 1976. Facebook was not invented or created until 2004. I think that's when Facebook was launched. But the internet and Facebook came after this law was drafted. And so what occurred in this case was Studio 8 put on Facebook their position about gender identity. Mm-hmm. Studio 8 did not refuse to cut anyone's hair. Nobody was refused service. So where does it put this case? It puts it into a pure speech case. The First Amendment in the U.S. Constitution, and that's Article 1 in the Michigan Constitution, has a very, very good batting average. It's up over 900. Meaning that pure speech is protected in America. We're allowed to say what we want with only some limitations. And those limitations include imminent lawless action. You cannot go on Facebook and specifically threaten a politician, your ex-spouse, your neighbor, because that's not going to be protected. Defamatory remarks, things that are untrue about someone. I know.
I'm familiar with some of that.
But then it gets into defamation is not easy to prove because you have to show the malicious intent and things like that. And then some advertisements are not protected. But, and it's for probably another podcast, the number of cases that the U.S. Supreme Court has heard in which free speech has won, in addition to freedom of religion, okay? And in this case, Studio 8 asserts that God created male and God created female, and that is Studio 8's prerogative to have those views, as much as it is someone to have a sexual orientation or a gender identity. The challenge is that the government is intervening here and telling someone what to say. So
Compelled speech.
compelled speech.
Yeah.
Exactly.
I've talked about that before, and it's one of those things. It's why I think this is this confluence of all of these things coming together, social media. That to me is why this is so important. It's I think that this Facebook post was, again, whether you agree with it or not, on its face, she enumerated some things very specifically. If you identify as anything other than a man or woman, please seek services at a local pet groomer. The outrage was that she was suggesting, and this is not what I think, this is what others have. I mean, I've read them, I've seen them, I've seen all the news reports. People are trying to suggest that she is saying that a transgender person, it is basically an animal or something crazy like that. And that's actually really not what she's saying. It actually looks like she has read Elliot Larson's Civil Rights Act and specifically said anything other than a man or a woman. We've talked before about the definition on previous podcasts. Merriam-Webster's dictionary, pretty much says, you identify as either a man or a woman. And she says that right here. But pure speech, compelled speech, that's the thing that I'm on the lookout for right now. And I think there's this huge surge to start compelling people. I see it all the time online. These TikTok influencers are going to, there's a Delta issue the other day with somebody that was associated with Dylan Mulvaney, the Bud Light character, who is transgender. This gentleman was at the airport and was filming himself being misgendered by a Delta employee at the counter. It ended up having the exact opposite effect and sort of made this fella at Delta, who was just basically standing up on logic, and the fella that was recording was gravely upset that he was being purposefully misgendered. And this is sort of where this thing, I think, is headed, is to try and weaponize some of these things within civil rights protections that have real meaningful value around race and sex and gender. And now it's kind of being siphoned off to the side to be used in this sort of way. Again, there are 3 people that have filed civil rights complaints. Apparently there are many, many more, according to NBCR. But these people want money for something they read on the internet. I can't stress that enough. They want money for something that they read on the internet. So if this is allowed, where does it go from there? This is why I'm talking about it. This is why this is maybe the 3rd or 4th podcast that we're talking about it. So compelled speech to me, sorry I'm ranting, but compelled speech to me is something that is totally the antithesis of the First Amendment.
And you got ahead of me on the money damages. And let's go back to the Detroit Lions, because they're winning.
Woo-hoo.
I won't cover the Pistons and the Red Wings.
Hey, the Pistons, they're setting records. They're setting the wrong records. But
I went on holiday vacation. I came back, and the Red Wings went on this skid. So don't quote me on the rules for a fair catch, okay? But let me just use this as an analogy. So you show me the catch, and you say to me, I think it's not a good catch. Now I'm going to say to you, what are the rules? Okay, here's the rules. Number 1, both feet have to be in bounds. I think that's the rule, and maybe just be 1, but let's just go with this.
College is 1,
and pros
maybe
is
pros
yes.
2.
The next question I'm going to ask you is, okay, what do you mean by inbounds? Well, neither of the shoes can touch the white line. Okay, now I'm watching the video. I look at his feet, and I can make a determination as to whether he was in bounds or not. What else? Can his body be out of bounds? Yes. but his feet have to be inbounds.
Control of the ball.
Control of the ball is next. Okay, now that gets a little subjective, okay? But anyway, you show me the definition of control. I look at the player, he's coveting the ball. He's not juggling the ball. I watch it in fast and slow. Once I know the rules, then I can make a determination on whether he was inbounds or out of bounds. But keep in mind, this is sports. As passionate as I am about sports, in the end, they don't win the game and life goes on.
Right.
This is different. This is the state of Michigan saying that they are going to take Studio 8's license and they're going to put them out of business. Okay, that's serious. That's not turn the football game off, the Lions lost, we're all upset. And we're passionate about it. But remember, it's still just a game.
An executive branch state agency.
Right. Number two, they're going to fine Studio 8. Number three, the individuals, and we'll cover standing in a moment, that are complaining are saying they suffered emotional distress and mental anguish from reading a Facebook post that did not include their name, their family's name, the names of anybody they know, not their employer, not where they live, and there was no damage to them, but they have their hand out requesting a check. And if they have standing, who doesn't have standing in this case? So discrimination laws penalize conduct. They do not penalize speech. So let's talk about the definitions, and then I want to give you a real example, which was the Colorado K case.
So we're coming up against civil rights
Yes.
versus free speech.
Yes.
Right.
Correct. And freedom of religion.
And freedom of religion.
Right. And are those defenses to the accommodation laws? And they're starting to be. Let's take the issue of race. I don't think there's any cases out there that say the Bible tells you not to serve a certain race. Irish, Italian, you pick any race you want. The courts are going to reject that because the Bible doesn't talk about that. The Bible doesn't say that a person's race is biblical. Religion, of course, the Bible is religion, right? And so we recognize all religion. So there's really no defense there. And I think going back to the 70s, to say the Bible teaches me that I can't hire women to work as waitresses, I can only hire men, is another one that would be rejected. But now we're in an area that does implicate the Bible. This case does not involve sexual orientation, which is same-sex marriage. It does involve gender identity. But let's talk about sexual orientation just for a moment because it formed the basis of back-to-back U.S. Supreme Court wins for the First Amendment. In Colorado, the Masterpiece Cake Shop, two gentlemen went into his bake shop and said, we're both males, we're going to be getting married. And the cake shop owner said, I will sell you any cake product that you want. I'll sell you a birthday cake. I'll sell you a donut. I'll sell you anything. But I will not sell you a wedding cake.
Is this 303?
That's coming next.
That's the mission.
Yes.
Okay. Yeah. Okay.
This is the Masterpiece Cake Shop cake.
Yeah, okay,
yes.
Sorry.
Because for him to make that cake, he's endorsing same-sex marriage. I have no position on gender identity, and I have no position on sexual orientation or same-sex marriage. I have a position on the Constitution. He told them that it violates my religious beliefs to share your views of marriage with you. I don't agree with that. The state of Colorado hammered that baker with fines and costs, and they came after him. The U.S. Supreme Court said that, number one, the baker denied service. But because his cake spoke, it was speech, that the First Amendment protected him. They did so on religious grounds, and that is this. The government cannot compel you to violate your religious views. So he won. Now, that case was decided on religion. It's very rare for the Supreme Court to take a similar case years later. So suppose the Supreme Court, U.S. Supreme Court visits when the police can pull your car over. They're going to do it once and tell you what the rules are, and then they'll be done with it for a long time. They're not going to keep taking those types of cases because they've already said to you what the probable cause is and is not. But immediately, I say immediately, maybe 3 or 4 years later, they took another sexual orientation, same-sex marriage case. Why? Because the first case was based upon religion. And some of the justices said, hey, what about free speech? We cover that too? So that's a 303 case.
Okay, yeah.
She's Colorado. She has a website, strictly a website, in which you can go to the website and here is a marriage. And these are the people getting married, and this is where they're getting married, and are they going to have children? This is their names, and so it's a website that you can, where do I register? When everything is going to be on there, and so she too denied service. They came in and said we would like same-sex marriage, and she said no. And again, Colorado was going to impose these complaints on her, but she went right to court. Because the idea now is before the agency can come for you, you can now go to court and get your rights established. Another win for the First Amendment, but this time under free speech, because that website was pure speech. And on the website, she said, I do not support same-sex marriage because it violates my religious beliefs. Why? Because she believes that the union for God is a man marrying a woman. It doesn't matter whether she's right. The same-sex marriage people could be right too. But she's entitled to the same respect that they are.
Right. That's key.
That's right. So if it is now lawful to have same-sex marriage, and we respect that, and that's what they want to do. But we must afford the same respect to people that don't believe in that. And the government cannot be the referee that says, I support same-sex marriage, but I don't support, and then penalize them.
Right.
This is the whole core of leaving England so that we can have our religious views and we can speak our mind about things. And
the separation of church and state.
Exactly. Right. And
to me, that's another big one that's going to be coming around here again in the next. Well, we got an election coming up here, so it's always thrust into the spotlight, anyways.
And you can see how James Madison is at work here. The legislature drafted a law.
That's my boy.
Gorsuch, right? That said.
That's my other boy.
That said, you have to honor same-sex marriage. The legislature said that, and the executive branch enforced it, and the judiciary said no. So it balanced out. Now, in Michigan, there's a case called Roush World in which there were 2 denials of service. One for same-sex marriage and one for gender identity, as they call it, transgender. But the Supreme Court only ruled on the same-sex marriage issue. But
these are both Michigan Supreme Court cases?
Yes, Michigan
right?
Supreme Court cases, correct.
And the other 2 were U.S. Supreme Court
That's correct.
out of Colorado.
That's correct.
Yep.
Now, the Roush World case, I thought, did a nice job for definitions, which the legislature adopted, I think. First of all, sex is whether one is a biological male or a biological female. I think I can accept that. You're born one or the other. It's on your birth certificate, required by the state of Michigan. And again, I don't have an opinion about any of this. I'm just going by what the definitions on the books say and what the courts have said about this. So number one,
this is the similar thing, right? When we were in court before, and we always said we're not going to argue the science, and we told everybody else don't argue the science, right? There was so much emotion around COVID and COVID science, and that's not what we were arguing, and that's not what is being argued here. Is whether gender is binary or it's a spectrum or any of that. That's not the conversation that we're trying to get into. Here, it's about the simple definition and how a person's religious views correlate with that definition as well.
Exactly. So once we explain that both feet have to be in. You have to have control of the ball. Once you know the rules, you should pretty much be able to look at the video and say whether it's right or wrong. And there's some disagreement because there's juggling and things like that. But these are the rules that we've been given. So number one, sex is whether a person is a biological male or female. Got it. Gender identity. Okay, that's the term that is now on the books in Michigan. Now let me stop for a second. You will hear people say transgender, LGBTQ plus, non-binary. I don't know what any of those things mean because they're not in the statute. I'm only going to do what's in front of me on this case. So gender identity is now in the statute. It's going to be effective in 2024. It's not for 2023. But let's go back to the Supreme Court, start at one piece at a time. Sex is born male or female. That's what the Supreme Court said, Michigan. That's not my opinion. Number two, gender identity. And I think the definition of Rausch's World is very clear. Someone who identifies with a gender different than the gender that he or she was born as. I got it. To me, those are bookends. You're born male or female, and you're welcome to become a male or a female. Perfect. Now I know what the rules are.
Yeah.
So the legislature adopted pretty much those definitions, as did the Traverse City ordinance. Okay, Gaylord can have an ordinance and Traverse City can have one.
Non-discrimination ordinance.
Exactly.
Yeah, yeah.
So you're welcome to have multiple levels. There's also a federal accommodation law, but it's in the Civil Rights Act, but doesn't have the teeth that the locals, and they wanted the local states to enforce, not so much the federal. It's not effective yet, but in 2024, sometime around February of next year, we're coming up on that, the law will be this. So we have race, religion, sex. We've added sexual orientation, same-sex marriage, doesn't apply here, gender identity. And they say this, it is gender-related identity, not an individual's assigned sex at birth. Okay, I got it. You're born with a gender and you changed your gender, but you're still a gender. Not my opinion. That's what it says.
Sure.
Traverse City ordinance, I think, is even more clear. The gender with which one identifies, regardless of that person's biological makeup. Okay, perfect. We got the rules. So everyone knows the rules now. You're born with a gender, but you can change your gender. That's it. Now, what did Studio 8 say? So Studio 8 said, now this is speech on Facebook. If a human identifies as anything other than a man/woman, please seek services at a local pet groomer. You're not welcome at this salon, period. Okay, so the law, the protected class is either a man or a woman, or a person that was a man that is now a woman, or was a woman is now a man. What did she say? If you identify as anything other than a man or a woman, well, that's not a protected class. If you're not a man or a woman, then what are you? Whatever you want to identify with. So I had to go to the dictionary and look up, if you're not an individual or a person, you're an animal or a thing. Now, people think that I'm being flippant. I'm not. That is looking at the law here. And what Studio 8 was saying is people that are identifying as personal property or animals, I don't agree with, because the Bible teaches that you are born a man or a woman. And most importantly, no one came to Studio 8 to get their hair cut. She's allowed to go on Facebook and speak her mind about her free speech, about her beliefs about the law, and articulate that. And because she did, the government wants to take her license. They want to fine her. They'll want her to write a letter of apology. She'll have to go to counseling with the state of Michigan, and she'll have to pay people who read this on Facebook. But let's talk about that Facebook for a second.